asking Trent the questions during the presentation. If we don't get to all of the questions, we will get back to you with them. June will keep a tally of them, and we'll be able to answer those by Monday. Also for CLEs, please, in the participant room, this is how we take attendance. We need to have your first and last name on how you signed up, so we can make sure that those who need to receive the California CLEs can. And June, I believe that is it. I'm going to go ahead and get started.
We're recording, just so everybody knows. So I've already hit the
Thank
record
you.
button. I already hit the record button.
Thank
Yep,
you.
I did. So
this presentation is being recorded, and it will be up on demand on the ACEDS website, which is aceds.org. Another quick thing is, for those of you in the San Diego area, don't forget to check out the San Diego Paralegal Association. And also, since there is no ACEDS chapter in San Diego yet, Orange County welcomes all San Diego and Inland Empire people until such a time that there is a San Diego chapter. So with that being said, I'd like to introduce our guest speaker today, which I'm very excited about. He is a personal friend of mine, Mr. Trent Livingston from ESI Analysis. Trent, I'm going to go ahead and let you introduce yourself, since, as I said before, you know yourself better than I do.
Oh, that's debatable at times.
Okay, that's true.
So, hi, I'm Trent Livingston. I'm CEO of a company called ESI Analyst. It's a company that specializes in data analytics for discovery. And what I've done in my career is I started out as a computer programmer with a little company, you may have heard of it, called Microsoft. And then I applied to this little organization called Electronic Evidence Discovery. This was back in 2001, before this stuff even existed. So lo and behold, my career evolved, and I've now testified at the federal and state level about structured data analytics, structured data discovery. And I specialize in that discovery that doesn't fit the mold. And I've been publishing some law journals and so forth and everything, but fluff aside, basically, one can call me a structured data analytics expert. Essentially, I look at data and I compare data and I can cross-reference data across stuff. And it's really exciting because today's day and age, that's what we have more of than we have documents these days. And so one of the things we're going to talk about today is mobile discovery. So I guess I'll just launch into sharing my screen. Is that correct? And we'll start with the presentation.
Yes, please.
So can everybody see my screen? Can you see the slideshow? Okay. So the modern mess of mobile discovery. We were talking about it earlier about all the different apps and stuff, and talking about children, and now they have more access to apps now than anything else. So one of the things about digital evidence is, and you guys probably all know this, but friend of mine, he's in civil litigation, and he made a statement to me one time. He said, evidence is our case. Cases are made up of three things: the evidence, the lack of evidence, and inference. And he said, basically, without those, that's all we've got. That's it. That's all the case is made up. But the important thing to remember is that this evidence needed to support claims and defenses. It often exists now only electronically. And we talk about this kind of cavalier these days, but when e-discovery first started, it was an add-on to a case. People were still discovering boxes of paper and file cabinets. Even as into 2007, when Enron occurred, if anybody recalls that, the great energy debacle that we had, they were shredding paper up until the last minute, and quote unquote shredding evidence. Well, digital evidence became part of that because email was a big part of that, and people were struggling to gather all that data. And at that point in time, if you compared it to today's data sizes, it was nothing. And this really kind of leads me into this slide of what discovery used to look like. Everything was printed. I mean, I remember getting CDs of data and everybody requesting blowbacks to paper, which is print it all out. And we were printing sometimes boxes and boxes of paper. I remember receiving a disc one time, a DVD, back when DVD burners were the big thing. And they said, yeah, they handed it to us on Friday and said, yeah, if you could just print it out and deliver it to us on Monday, that'd be great. And I said, which semi do you want me to deliver the paper in? And they were kind of taken aback. I said, you're literally going to get hundreds of boxes of paper from this. We should talk about this a little bit more. And that's because they didn't understand kind of what the difference between electronic and paper was. Now that's completely changed, but that's because computers were isolated. They were just these small PCs. A hard drive was about 20 gigs. And the data was limited. I mean, we literally had Microsoft Office and we had email. Now, when we talk about email back in the day, there was Lotus Notes, there was GroupWise, you know, so I'm dating myself significantly here of when everything started, but it was very limited as to what electronic data was present. But now we turn the corner and we see that today, one user, one person, on average, every single minute of the day generates 100 megabytes of data, all right? And this is this digital footprint we leave behind everywhere we go. Now, we don't even realize we're generating this data. We're creating data because we're carrying a mobile device with us. We may have our laptop. We may plug in the laptop into a VPN in a hotel room, connect to that Wi-Fi, create a video, take some pictures, and you know, we think pictures are innocuous, but they embed all this information in them, like the location, what direction we were facing. It's just massive. And then every time we make a phone call, that phone call is not only being logged on your device, but there's a cell tower record of that same phone call being made, the time that it was engaged, the number that was called, the triangulation of your phone when the number was engaged, and also, you know, the latitude, longitude of that triangulation. Whether you send an SMS or an MMS message is also logged by those cell towers. It's pretty amazing what's going on with that. So, and I think we also noted that if somebody has a question, we can interject and talk about that during the CLE. I'm happy to take questions as we go. So I just wanted to make a note of that. Well, what's happening is all this data, WhatsApp, and then all your favorite apps, WhatsApp, WeChat, all these things are logging your phone. And as much as people say they're not discoverable, they are. And we'll go into some cases later on where even though someone has this type of data, if it is ephemeral, in other words, like Snapchat, where it goes away after a little while, if they're under a preservation order by the courts, they still have to keep it. They have to figure out a way to store that data and keep it and preserve it. And if they don't, they're subject to sanctions, fines, etc. So it's really rather interesting. So what does all this data make discovery look like today? Well, when you talk about what it looks like today, we see this new wave of data where now we have massive rooms of reviewers, tons of people reviewing data because the volumes are so large. And the data volumes are voluminous because there are all these enterprise applications stored on massive servers. Now, we talk about this as the cloud, but wherever the cloud is, there's racks and racks of servers like this someplace. And you know, AWS has huge data centers, Google has huge data centers, and this is where all this information is being stored. And so evidence, as we call it today, digital evidence, is no longer limited to what we call the usual suspects, which is just what we're talking about: email, Word documents, Office documents, if you will. Because now we're seeing things from WhatsApp. You know, you're seeing computer logs as evidence. For instance, I recently worked on a matter where their timekeeping system was all part of the evidence being assessed. And this was a timekeeping system that was accessible from mobile devices out in the field where they had to log in. They logged into a screen, they logged in that they were on the clock, and subsequently all those records were because of a mobile device connecting to a central cloud server, logging them in, punching their clock, if you will, you know, their virtual time clock. Slack. Who doesn't use Slack these days? Or Microsoft Teams or something along those lines. We're all communicating remotely, often mobile, laptop, phone, whatever it may be. Facebook, social media. You can do a takeout of your social media. And there's, you know, inside of that takeout are all your Facebook messages that you sent. We actually did discovery recently on a Facebook message account that had over 500,000 direct messages. And they were avid Facebook marketers. So it was, a lot of messages with their marketing teams and so forth. And we talked about cell tower data and how much data is captured there. All a product of mobile. Pictures. I touched on this briefly, but if you can ever get an app called an EXIF reader, EXIF, you can, and there's mobile versions of these free. So you can download one for your phone and you can open up a photo and you can look at that photo. And when you look at that photo, if you have location services on and so forth, if you look at the EXIF data on that picture, which is essentially the metadata of that picture, it will tell you, if you took it on, say, an iPhone, it will tell you whether you took it with the front-facing camera or the back-facing camera. It will tell you the aperture, the f-stop. It will tell you what direction you were pointing, whether you're pointing north, south, east, west, southwest, and it will give you the longitude and latitude of that photo, as well as your elevation and your speed at which you were traveling. So I actually tested this. I was in the back of a boat down at a dock. It put my elevation at 2 feet below sea level. Why was that? Because the tide was going out. I was facing southwest when I took the photo, and I was literally traveling at a speed of something like 0.02 miles per hour. And the reason why is because the boat was moving ever so slightly. It recorded all of this and recorded that I took it with a back-facing camera, the f-stop, the aperture, and everything. Why is that important in digital evidence? It could show someone was at a certain position at a certain place in time. These are used often in accident investigations. They're used in placing someone at a scene. And I don't know if you've noticed the trend lately in Europe. It's very, very big. But many cars now are equipped with video cameras to where they're constantly recording. So accident investigations usually have tons of video to go through. The police are using all the video cameras around. So all of this mobile data, all this stuff that is mobile, that is moving around, is always recording. So that gets us into videos. I should have clicked that one to talk about videos. We talked about our laptops. The type of stuff we're recording there these days is, VPN activity, logging in, logging out of a device. All this is still mobile, because we're carrying it around with us. You log into a coffee shop, those kind of things. Voicemails from WhatsApp, those kind of things, they're recorded. You'd be surprised, all the chat and everything like that. Snapchat, we were talking about that. Does anybody know that Snapchat has what they call ultra secret Snapchat account? So if you create a Snapchat account, you can create another account within your account that is ultra secret. It has a second password, so it can be completely obfuscated and hidden. So that's kind of scary when you have kids. Microsoft Teams, basically Microsoft's version of Slack. It's a quagmire of data. It connects to SharePoint, all these files that are linked and so forth. And we talked a lot about geolocation. This is being used in criminal investigations. It's being used for triangulation of different users, correlating it to cell tower data. I was actually involved in a investigation doing data analytics around a love triangle that ended up in, sadly, a murder. And they were using that data along with the text messages she received on her phone to triangulate the two suspects as to their location on the night of the murder. So it was really interesting from that standpoint of comparing all these data points to try to put somebody in a place and time at the approximate time of death. Talked a lot about calls, but essentially, here's your suspect. It's the mobile device. And we often joke about it in the criminal world. If you're in criminal litigation, criminals don't send out PowerPoints that, hey, this is how we're going to rob the bank. They don't do Zoom meetings. They use burner phones, and they use a lot of them. And so triangulating, these phones, putting them to an individual. So if they have 4 phones, what numbers were they, comparing them? That's all a process of getting through this mess of data, because data is just that. It's piles and piles of data, but it does not become useful information until it's analyzed and broken down in a readable and understandable format to produce clear and concise information. And that's really important in the context of a case, because when you look at all the common data requests that are out there, email, chats, photos, all the stuff that we just talked about, without understanding how they intertwine and connect, you cannot tell the story.
I had a quick question.
Yes, sure.
You were talking about burner phones, and I don't know if anyone else here is curious, but we see a lot of stuff on TV surrounding burner phones. With as far as technology has come, is it easier for us to identify or track down users of those burner phones, or has that technology from a burner phone perspective just gotten smarter, and are we still facing the same difficulties with, associating individuals with burner phones, that type of thing?
Well, and we're still seeing the problems. I mean, a burner phone is just that, it's a burner. So it's nobody's registered the account. Nobody's registered to the IMSI. So there are two identifiers on a phone: an IMSI, International Mobile Subscriber Identity. The IMSI of a phone is registered to the account, and that account, that IMSI, that number follows you around. So if, let's say you're a subscriber to AT&T, as long as you're a subscriber to AT&T, that identity, that number, follows you through AT&T. The life of every time you change a phone, every time you change a device, that number stays static. But when you're on a burner phone, that is registered anonymously, if you will. Nobody knows who it is. It's just this number, if you will. So tying someone to a burner phone is literally seizing it from that individual, and then recording that phone number and that device ID in the forensic manner, and then knowing that it's associated to that person. Then you can explore other devices that have that number and find the communications around it. So there are ways to figure it out, but it's putting the pieces of the puzzle together.
Yeah.
That makes sense?
Sorry, I didn't mean to interrupt you. Yeah, burner phones have always been something that's a bit innocuous for me to wrap my head around, so.
Yeah, not a problem. There's another number that's also on the phone, which is the IMEI, International Mobile Equipment Identifier. Okay. The IMEI is the serial number to the device. So that's a way to tie a device, a number to a device, similar to logging a serial number of a hard drive in the forensic world. This whole bag and tag kind of thing that you see on CSI, that's kind of the way you bag the phone, you tag it, you shut off Wi-Fi so nobody can remotely wipe it, you get it into a sealed room so that if you do power it on and power on Wi-Fi, it essentially is blocked. It can't get a wipe signal, because there's been stories of people remote wiping devices before they're imaged. And so it's this quick, get it into a sealed box. But those are the device identifiers often used, and then you use those to coordinate with the IMSI. You use that to coordinate it with the cell tower information and that kind of stuff. So it's really, like I said, putting the pieces of the puzzle together and telling the story, because without the story, there is no case. As we go back to our first statement of, evidence is everything, every case has a story behind it. And if you can't clearly tell that story in court in a clear and concise manner, essentially, you're going to lose your case. You're not going to, in a criminal matter, you're not going to have beyond a reasonable doubt. In a civil matter, you're not going to have the preponderance of evidence in your favor. And we all know that in civil, it's about telling the best story. And oftentimes that story revolves around what someone said to someone else. These text messages that we send so fervently. I mean, we communicate more in text now and in greater volume than we do in email. Why? Because it's short messages, short to quick. And when I say text messages, I'm not just talking about, SMS and MMS and iMessage on your phone or something like on your Android. I'm talking about all the different apps we use to communicate. Sometimes tracking those patterns through all the device of all the different communications and where we switch mediums is one of the hardest things to do. So, and that's because it's not a document anymore. We go back to the world of early discovery where everything was a paper, it was printed to paper. And that's the challenge we face right now in electronic discovery, is that the courts still revolve around paper and bait stamping and everything like that. So how do we get all of this information into a document? It becomes very hard because it's really important to display something in a usable format. You know, the FRCP says in a near native format. Well, what is native? I mean, if you look at some of the things that are native, this right here, and it's hard to see, but this is a dump from Slack. That's what native format Slack looks like in the back end. It's a bunch of computer code. It's what's known as a JSON object, which is JavaScript Object Notation, JSON. And it is literally computer code markup that gets interpreted into that message you see on your screen. You know, this right here is a Facebook chat and how it's broken down. Again, a JSON object. It's not the same, though, metadata-wise and field-wise as Slack. There's no standardization anymore. It is literally up to the app creator as to how they want to map things. And it's back to when I talked about the early days of ediscovery. We had Microsoft Mail, we had Novell GroupWise, we had Lotus Notes. All of them followed different formats. And then they created these things called RFCs, and they're essentially standards for communications. And they said, listen, any email being sent will always have these fields. It will log this so we can exchange them and they can all work together. And everybody came up with this, you know, this plan. Well, then mobile devices came around and people said, what plan? We don't need a plan. We'll just do it how we want, because they can. There's no need because it's all encapsulated. There's no server. This is what's known as serverless communications. It literally sends it out. It gets logged in a third-party application database that they're tracking, and they're grabbing your information, Facebook being one of them, using it to market to you and so forth. There's no regulations around it. There's no model that they have to follow. They can essentially do what they want. And then subsequently, it then looks like this. When we get it from the device, it looks like a big Excel spreadsheet of data. And if you've ever been involved in review of mobile device, this is actually a screenshot from a Celebrite report. And it's just a bunch of date, times, the messages in one column. You see participants, there's no chat bubbles. It doesn't look like a chat. It's really hard to review because it's like trying to listen to 20 phone calls at once. You know, there's this thing that we created back in the day of I say that loosely, phone calls. And this goes back to old technology in today's day and world. Phone calls were really challenged when we first created the telephone, believe it or not, because they said, listen, we can't run enough wires to get all these people to have phones. So they created this thing called time division multiplexing. Sounds complicated, but essentially think of a wagon wheel. And that wagon wheel is cut into little pie shapes. And what they did is they said, well, we'll run multiple conversations over the same wire, and we'll spin that wagon wheel as fast as we can. And so when you're talking on the phone, you're actually hearing a staccato of the other person's voice. It's just so minute, you don't hear it, but it's spinning all those conversations, and hundreds of thousands of conversations are going over one single wire. Well, this is now what we're doing with chat, is we're sending all this through the internet. It's millions of messages being sent every second, and it subsequently goes out into the ether, if you will, and ends up on somebody's device because of those identifiers we talked about. I said, I wanted to send this to this person, and it goes, and it doesn't hit a central server, especially SMS and chat. It just goes from one phone to the other. What does that mean? Well, it means sometimes the timestamps are different from the person sending, the person receiving it. They may be 2 seconds difference. It may show up differently on one person's device because they're an Android versus an iPhone user. Group chats, all kinds of things. There's so many nuances to it that it's literally mind-boggling. And this data problem is what's compounding discovery, because we're faced over the next decades, we will be faced with an ever-growing data problem. And it is challenging discovery because the amount of data we're generating. As I said, one user 100 megabytes every second. If you do the math on that and say, okay, if we needed to print out to paper, each person is generating terabytes of data a year. So if you said, well, if only 1% was potentially relevant data, you would still be looking at millions of pages that needed to be printed out per individual for the courts for process. So our court systems are overwhelmed. Our law enforcement is overwhelmed. The amount of data being collected for instance, surrounding the Capitol riots is staggering, because they're collecting all the social media data, all these chat app data, all the geolocation data, the phones that they grab, everything like that. And it takes a lot of time to get through everything. So what's driving this problem? You know, and this is something that is always a question I get is you know, why do we have this problem? Well, back to the whole mobile problem, it's because of connected devices. So back when Enron occurred, 2007, there were about 2.2 billion connected devices. That seems like a lot. But today there are over 50 billion connected devices, and it's just growing. So one of the things, there's, I can't remember the law. There's a name of the law, but essentially it states, and I can't remember who came up with the whole thing. It essentially states, as the cost of computing drops, the amount of devices grows by twofold. So every time it drops one segment, it multiplies by 2, essentially. So that means that as devices become less expensive, storage becomes less expensive, computing becomes less expensive, it just further compounds this, because we're going to create more and more devices and more ways to connect. And when we do that, it's outpacing a court system that is still working with printing everything to paper and putting it in binders. And if you think about that and you're like, what are we going to do? We have to solve a problem. There is a massive problem on the horizon. It's already hitting us, but the courts don't, there's literally decisions where the courts go, I have nothing to base this. There's been no decision about Fitbit data before. There's been no decision about, you know, this before that I can formulate my opinion on. So I have to make a ruling now because I have a case in front of me where, you know, there wasn't one before. And so it's really changing the landscape of our courts. So global data every minute, this is every minute. Now, some of these numbers are also old. For instance, the collaboration tools, we actually estimate that closer to double the 30 million mark. It's actually closer to 60, maybe 100 million. So this is how many messages are being sent every single minute across all these 4 different mediums. One is social media. So your social media chat apps and everything like that. SMS, MMS messages, standalone, that's just your text messages. Collaboration tools, like I said, it's been really hard to determine this number because Slack and Teams do not publish statistics. Slack recently just published some statistics around their users as part of their quarterly reports to their shareholders. And the estimation is way off the chart. So we think that number is closer to like 70 to 100 million, especially because COVID, because it moved everybody off of seeing people face to face, actually having a conversation. Messaging apps, of course, are you know, it runs the gamut of what you can see. So, you know, it can no longer be ignored. We can no longer stick our heads in the sand. Literally 2-3 years ago, you know, I was talking to some attorneys and they said, yeah, we're not really worried about mobile data. You know, it's corporate. So anything they say is pretty much isolated to email, and, you know, they don't use their text messages. Oh, how the world has suddenly changed. It recently involved in a matter where, you know, they failed to preserve text messages properly. And one of the key individuals being investigated had the typical 30-day setting on their phone. Well, they had to go back and reconstruct text messages by gathering all these other individual phones that were in this individual's contact list to say, we need to reconstitute all these text messages because we must produce them. And so if it's not on one device, it could be potentially on another. So it's really kind of interesting where the courts are going. And we need to be aware of these changes so that we're prepared to make the right decisions when it comes to discovery. There's no perfect case. There's no perfect playbook, if you will. It's really about understanding the matter, talking to the individual or individuals that are involved in the matter, and understanding what methods they use for communication so that they can subsequently, you can learn as, a legal professional working a matter, you can learn what devices need to be preserved, what preservation orders need to be put in place, what do we need to inform our client of their obligations and what they may be subject to, because a lot of this can go to there's been malpractice cases filed by clients against law firms because the law firm didn't advise them properly on what to keep, what not to keep, and they ended up losing a case or being sanctioned on a case because they weren't properly educated as to their obligations to the courts.
And Trent, when we talk about this, we have a really good question that came up in the chat, and this is a topic that comes up, I hear a lot now. So Barbara wants to know, where does reasonableness come in with all of this?
That is a good question. So reasonable, what is reasonable? This is a really broad question, and it comes down to often a financial calculation. So when reasonable was defined as by the courts and the FRCP, it was really kind of one of those things to say, what is the value of the matter versus the value of discovery? And, how much is it going to cost for discovery versus actually producing this data? But also there's the other factor of how prevalent or how relevant are these communications, or is this digital evidence to the matter itself? So each case is different. Unfortunately, there's no perfect calculation for this, but let's say there was a $10,000 lawsuit and the discovery was going to cost $100,000. Well, at that point in time, it becomes very unreasonable to force discovery of that cost and nature over that size litigation. And, it's one of those things that, of course, $10,000 probably end up in some small claims court, but it's just comparison of costs. But then there's other cases where, there's one that we're going to bring up here in a little bit that I'm going to talk about a Fitbit matter where they actually had that debate and they said, well, this is just phishing. And they said, no, it's really relevant because of X, Y, and Z. So this is where arguing the case in court during motion practice, and I'm not an attorney, mind you, so I'm a technologist and just testified, so anything I know about the legal world has been through osmosis. But from what I've been told by legal professionals is this is what motion practice is about. This is where filing a motion and being able to justify it and understand it is of the utmost importance, because the only way you can educate the courts as to the reasonableness of a request is by really understanding what's involved in that request. And I've seen a lot of counsel go into their meet and confer and agree to guidelines and stipulations in discovery before really understanding the depth and the breadth of what that discovery they're agreeing to really involves. And that's where you have to be educated before you even hit that conference, before you even hit that stage of the case. You need to know, because that's when the reasonable arguments are going to come into play. And that's when motion practice is going to be very important to motion to quash, motion to compel, whatever it may be, is going to be there because you need to understand what arguments you need to make at that point in time. If that's helpful, I hope that answers the question.
Second question came in is, how do you protect, Maribel wants to know, how do you protect, hold on, how do you protect clients in order to protect this type of evidence?
How do you protect clients in order to protect this type of evidence? Well, if they've been ordered to produce it, there's got to be some sort of review. And so PII can be protected, confidentiality can be protected, data that is innocuous to the case that doesn't matter can be quickly excluded. but that's the process. I'm not sure if I'm getting the whole question of it, but if the data is said to be relevant and needs to be produced, then protecting your client is about making sure they understand their duty to preserve. And if they don't have the ability to preserve it, having a professional involved to help that preservation be completed. In other words, imaging the device, capturing the data, getting a download of Facebook, and then also educating the client as to, hey, don't go deleting your data as soon as, don't go in and run and delete stuff. You can't. It's the, I don't know if there was a case where a mother deleted text messages of her sons before she handed the phone over to the police because the text messages made her son look like a frat boy, is what she said. And the police didn't stop her either, which was, I found really fascinating. But that's something that protecting your clients is telling them not to do things like that. That's a way to protect your clients is don't put yourself in a position of spoliation where you had control of the evidence and you knew it was relevant and you deleted it. Don't do that. So that's really an important thing that needs to be discussed with the client. And they may say, oh, there's really embarrassing information in there. I did this or I did that, and I talked to this person. And there's been stories of affairs being uncovered during, what is innocuous civil litigation. And then all of a sudden they're like, my marriage is on the line because I got these text messages and so forth. Well, that's what attorneys need to grapple with these days, is you're going to have to tell your client, well, this stuff is discoverable. We'll withhold that evidence because it's not relevant to the matter, but you need to tell me where that evidence exists so I can be aware of it. Help me help you is kind of the expression there, if you will. I hope that answers the question.
Last question is, how can we be better prepared for court in e-discovery with overwhelming global data? And is there a differentiating approach between on-prem and cloud tech? And the last part is, I could easily answer, but I'm going to let you take both of those.
How can we be prepared? Education, understanding, as I said, knowing the case, knowing what's involved in the case. Is there a difference between on-prem and cloud? Oh boy, the differences are in the great numbers. It really depends on your case. On-prem, the cloud was developed because of these massive data repositories. And if you look at what can be done on a single laptop or a single on-prem server compared to what can be done in the cloud as far as data volumes go, the cloud is the clear winner. There's analytic tools that are built into cloud APIs and so forth that if you're on a desktop is way underpowered, laptop is way underpowered to do these massive analytics, if you will. And sometimes being better prepared is just knowing where the data is going to come from and what data sources you need to tackle. So it's, how can we be better prepared as the court system goes is oftentimes we're in the conundrum of the people who are sitting on the bench in the judiciary have moved up through their careers from being a lawyer or something like that, or well, of course, being a lawyer, but evolving into sitting on the bench at this place, then getting to this bench and so forth. And they're so removed from discovery that they don't understand it. So breaking things down clearly in motion practice and in any kind of expert report is really important to, as I've always been told in my expert reports, write for the 6th grade level, document for the 6th grade level, use images, use very simple descriptors. And it's not because people are all educated at the 6th grade level, but you break it down in simple layperson's terms so that the courts can clearly understand it, because that is one of the biggest problems you'll face, is making sure the court understands the argument for or against the data source, understands the potential costs surrounding it, and can then work through those issues in trial. And then, from a SaaS versus desktop, it really depends on the size of the data, what you're trying to accomplish, and what's trying to happen. But from a global perspective, I'm more for SaaS. I think that the world needs to adopt the SaaS model more often from a cloud perspective, because it allows more collaboration, expeditious review, analytics, etc. I hope that answers the question.
Perfect.
Any others?
And I'm not sure if I'm going to read you directly the question. Glenna said, where are businesses getting involved by helping with building, implementing policies and practices? Oh, she said, yes. She wants to know if they're helping building cases that will help e-discovery when there's a legal case. Are businesses getting involved with that?
From a standpoint of creating models and so forth, are corporations and so forth being proactive?
Correct.
Okay. Kinda. Depends on the corporation. I wish we had more proactive corporations out there. I think a lot of corporations are realizing, a lot of businesses are realizing, especially those that are exposed to a lot of litigation, are realizing that they need to adapt better practices and be better prepared, and creating, playbooks around this stuff. I think that it's still an evolving landscape. And I think that education is only going to help. I don't think anything's perfect, but it's the best thing I can say there is it's evolving. It really depends on the company, but we are seeing more activity around that.
I will say, without giving specifics for the company I work for, that we have noticed a trend, an interesting trend, a good one, where corporate legal departments are adopting e-discovery software before they even hand that case over to their counsel, right? So they're already onboarding e-discovery software to get all of their collection done and ready to go before they even get their corporate counsel onboarded for that case. And then having that corporate counsel then use that e-discovery platform. And I find that interesting because it sounds like corporate America has figured out there's a lot of data that needs to be reviewed to figure out the value of the case, whereas attorneys, in a lot of instances where I've been involved, are very hesitant to adopt legal technology as a means of analyzing that case. So I think through the sheer forcing of corporate America, we might see lawyers tech up finally.
Yeah, in the corporate world, we are seeing a trend because they're trying to mitigate their risk. We talked to a corporation the other day, and their whole plan was, my job is to find the smoke before it becomes a fire, and then subsequently put out that smoke beforehand. Once it becomes a case, then be able to turn over what evidence they've collected to the counsel to then do what they need to do with it. Whether it's in that same e-discovery system or not, doesn't really matter at that point. It's more of their whole job is to make sure that everything continues to run smoothly and to weed out the bad actors before things happen.
Right, that early case assessment process, I think, is becoming more and more key to a lot of corporate environments, which I think is a smart way to go, right? If you do your upfront due diligence, then you're prepared down the road. But so hopefully that helps answer the questions. Eric wants to know, it seems like privacy issues will continue to pop up surrounding how much do we have to divulge within reason? Does anyone know how in general the court's tending to lean, vet, and rule on issues? When does the entity have the right to obtain one's data?
And some of these case examples in here actually kind of go over this. So this is where it really kind of depends on the case. These case examples are really kind of interesting here about this WhatsApp e-discovery, because in these cases, it was employment litigation where these individuals set up a WhatsApp channel to bully a female coworker. And it was only discovered after one of the individuals left the company and turned in their corporate device, and they didn't delete the information of it. And then subsequently they were found to have, these other individuals were to have gross misconduct and so forth. So privacy really depends on what is the nature of the matter. I know that in several cases we worked, especially around mobile data, privacy is the utmost concern, and parties have been very proactive about entering into privacy agreements right off the bat. So this goes back to the meet and confer. of establishing clear criteria of what is going to be considered PII, personal identifiable information, or essentially private information. So especially when it comes to mobile device discovery, there is no rule that, hey, pictures of my family should not be in this case, you know, and these chats, these phone numbers are with family members. So therefore, you can easily weed out these private conversations and these private messages by doing proactive work in the beginning to say, I want to establish, you know, with the parties, what is considered private. Here are the phone numbers that I've been told are mom, dad, sister, brother, daughter, whatever it may be. And we've agreed, we're going to agree that any conversations that include these phone numbers or include these social media posts or anything, anybody in these names will be excluded as confidential information. The courts are respecting that. When it comes down to things like these employment matters, that changes the whole dynamic of what is private and what isn't. This one is another one that's really kind of interesting. This is the Fitbit data I talked about. It was about an artificial hip, believe it or not, and it caused long-term pain and reduced mobility. Now, this case is really interesting. You can go in and explore it. But the court literally said, hey, I don't have much. The judge said, I don't have much to really base my opinion on. I can't find any precedent. So I'm going to rule that this is actually you know, relevant data and you must turn it over. And that's the other thing when we talk about mobile data is we're all wearing these, you know, the wearables these days. And these wearables become massive sources of information. In criminal cases, their Fitbit data has actually been used to determine time of death because of the heart rate stopping and the steps taken. In one criminal case, it's actually online. I wish I would have put the link in here. The case was solved because of multiple factors, all surrounding the Fitbit. One, the heart rate of the victim was found not to have elevated before the murder, which means the person recognized their attacker, because when you see a stranger, especially one that's broken into your house, your adrenaline is going to spike and your heart rate is going to spike, especially when they're coming to attack you. That was the logical argument. The other thing is that the individual who said that, you know, he wasn't the murderer claimed that the individual had just got home, et cetera, they were, you know, accosted in the kitchen and they were subsequently killed. Well, the Fitbit data found that there were numerous steps taken. The Wi-Fi on the car was also connected. It showed when it connected to a different network. So it showed when the car arrived home, how many steps the victim had taken from the point of time of arriving home to the point of murder, as well as the exact time the heart stopped. That didn't correlate with the story at all, didn't correlate with the timing at all. And then with the heart rate situation, they were able to determine that, you know, she was killed by someone familiar and in the house already, which was her husband, you know. So they always say first person to look at is the husband, right? Or the boyfriend, or in my wife's case, the girlfriend. Oh, I don't have one. So, you know, Fitbit information, again, another mobile point. So really kind of interesting case law is evolving around this. So it's a lot of really interesting cases, kind of fun to read about in some ways. This case is Snapchat videos. So this person is not the brightest. They produce Snapchat. Well, Snapchat has a 30-day deletion. So if you export your Snapchat, and you can export it via the online platform, it says, hey, this photo or this link is only accessible for the next 30 days. If you don't get to it, then it's no longer valid. And what they do is they place a token on the back of the URL that says you have authorization to download this. Well, by the time they produce this list, the 30 days had expired. So plaintiff said, or defendant said, hey, we need this production again because we can't get a raise. Well, the person did it again. Well, guess what? In between the first production and the second production, they deleted 11 videos from their Snapchat, from their memories. Well, can't do that. They said, oh, I was trying to clear up space in my phone. Well, they ruled breach of preservation duties and subsequently sanctioned the individual. So, once again, educating your client is what they can and can't do, making sure that anything they do on their mobile device is recorded, it is captured, it is imaged, it is downloaded from their social accounts, because some of these things, you can't get them off the phone. You got to go directly to the well. You could get more data from Facebook Messenger from Facebook than you can from the phone. You can get more text messages, MMS messages from the phone. You could get it from the iCloud backup from your Apple device. You could get it from an Android backup. There's all different places to look. There's never one location. It's never always just on the phone. It's never always on just the computer. It could be in the cloud, on the computer, all these different locations. So that concludes my slides. And I'm sure we have a few more questions to answer before the time expires.
So Maribel asked, would ediscovery help if you don't have tangible evidence in a case? Meaning through ediscovery, we could find text messages of witnesses.
Repeat the question again, I'm sorry.
So would ediscovery help if you don't have tangible evidence in a case? Meaning through ediscovery, we could find text messages of witnesses. And I will preface it by saying, I don't think anyone will let you go on a fishing expedition, but.
Correct. I mean, you're not going to get authorization to just go on fishing expeditions because you think there's something there. The argument of we don't know what we don't know doesn't work. But if you can prove connection between X individual and potential text messages, that's a scenario there. So it's about looking as to who texted whom. Some of these data sources aren't going to be accessible. Like, for instance, it's really hard in a civil litigation to subpoena cell tower records. They're not going to turn them over to you. Criminal investigations, absolutely. Criminal investigations have more carte blanche to those kind of things, but they still need to have reasonable cause. They still need to justify it. So if it's justified and it can be argued that it's justifiable and it's targeted, in other words, you can't just say, I want to see all their text messages. You have to be very focused and narrow, because that's what the courts are going to allow, is if the request is targeted of, I want to see all WhatsApp conversations between these two or these three individuals, or involving these individuals through this date and time, because they're highly relevant to our matter because of X, Y, and Z. And this could be, taken from deposition that this person said in deposition. They used WhatsApp to communicate. You've got to put the pieces of the puzzle together. You've got to tell the story to the courts to get them to understand why it is important. So that storytelling piece is not just for the final court case, because as we all know, less than 10% actually see the inside of a courtroom. Most are settled in much earlier on in the case. It could be during an arbitration, mediation, something like that. These are where the cases actually get formulated and argued along the way, and the story evolves. So it's always knowing the story at each step of the way.
Yeah, I think so. I always say that knowing how to craft your request for productions is key, right? And then getting that ESI protocol in place, because we were involved in a case where we were asked specifically, and this was a real estate case for the last firm, specifically for text messages, but it's because the business owner, when he was out of the office, would specifically text instead of email certain key individuals involved in that negotiation process. So we did have to hand over text messages between certain key parties that were involved, and it was surrounding a project. So it was project-based text messages where certain individuals were involved. So looks like everyone said you answered all their questions though, Trent. So thank you so much.
I'm shocked. Well, I really enjoyed this. I mean, it's a lot of fun. Mobile discovery, as I said, is much more than a phone. There's a lot of different data sources, and it's really kind of a fascinating area, an evolving area in e-discovery. The data sources are just so numerous and so vast. I think you'll find it fascinating. And looking out at case law and stuff like that, you're going to see more and more rulings around this. As to the privacy issues, you know, there's a lot of things that we're really starting to attack, and it's really new. It's cutting edge from a standpoint of there's still legal ground to be covered. And there's a lot of legal rulings that are going to probably change the face of this as we go forward.
I definitely think so. Two things. One, for those of you that are looking at the chat, Christine Custodio Suero posted to connect with her on LinkedIn. She is the NALA board rep for the San Diego Paralegal Association, and I encourage people to really reach out to her. Two, Eric says, in regards to privacy, what about EULAs? It seems that most agreements strip the users of any real privacy to utilize the app in a useful manner without giving consent. Who really reads all or most of an app's EULA? I never read the EULA, by the way. I just don't. Like, it's just assumed if I'm downloading an app, you're getting my shit and I have no control over it. So, and I think most of us do it right. But it's like, how bad do you want that app? And never choose to use a free app, because Lord knows they're getting all your shit to resell.
There's a phrase in software. So it's one of the most interesting phrases. So first of all, there are only two industries that call their buyers users. The first one is the drug industry. The second one is the software industry, believe it or not. If you are not paying for something, you are the product. So when you agree to that, you are usually waiving a ton of rights, a ton of privacy rights. And, you know, that's the big controversy in the courts right now of the power social media giants have and the wealth of information they control and how manipulative it can be. And that's a debate, and that's a CLE unto itself.
And one of the things I find fascinating, and I've said this in prior classes, I haven't talked about this semester in my class, but Americans freely give up their rights a lot easier than Europeans do, right? And if you haven't sat in on a CLE done by Qualcomm, it's very interesting, because I sat in on one a couple of years ago where they talked about how difficult it is to test their technology in Europe, because a lot of the privileges that Americans happily click through on those EULAs to test things out and try this new free whatever, Europe doesn't provide that nearly as easily. They protect their citizens just a little bit better. Americans were like, free? Sure, I'll give you my kid, my house, and my dog, right? But hey, I can take a picture for free and share it, right?
That's because the EU privacy laws are much more restrictive. Our federal government has not enacted the level of protections the European Union has, unfortunately.
Right. I definitely think so. And again, we are like just bedazzled by that whole, it's free. And I'm like, nothing's free. There is nothing free, right? So, and I try to.
The only social media platform you'll find me on, and it's even hard to reach me on that platform, is LinkedIn. I do not use Facebook anymore. I'm not on Twitter. It's not that I go off the grid, but I don't get on the apps anymore. You know, I actually, I'll text message, and then I'll actually tell people, just give me a call. And they're like, what? You use the phone?
Have the rotary dial set up, right?
Get the rotary dial.
Look at a phone.
So thank you, everybody. I really enjoy doing the CLE. So, and you can connect with me with LinkedIn. I usually every week I go in and I connect, and there's ways to get a hold of me. So you'll see me, Trent Livingston. I think I'm one of the few on there with that name. So.
Thank you so much, Trent, for presenting today. It was great information. If you have any questions that you forgot to ask and can want to follow up with, you can email members@sdparalegal.com or Orange County at ACEDS, ACEDS. Oh, I'm sorry, you're right, .org. Did I say .com?
Yep, it's .org for both of us. Okay,
yeah, you know what? I need more coffee. Or at least something with more caffeine in it. So let me do that again. It's members@sdparalegals.org or Orange County at ACEDS, ACEDS.org. Also, remember, in another half an hour, we're going to be starting our introduction to body cams presentation. So take your break, fill up on that morning coffee or your favorite beverage, and we will see you in about 30 minutes. Thank you again, Trent. We really appreciate your Saturday morning.